Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, thank you, everyone. You guys did it. I asked for a bunch of comments on this video that we did just yesterday, and you guys did not disappoint. I got a ton of fantastic comments, and I wanted to know, what do you think should happen to Mr. Hero Delivery Guy, this guy right here? And I had given you 4 options. Now, I got to tell you that a lot of these comments were fantastic to the point where I'm going to highlight a few of them tonight. And some of you came up with some options outside the 4 that I've given you that I thought were incredibly well thought out. So let's spend a few minutes today and hear about how our viewers weigh in on Mr. Hero Delivery Guy. Okay, before we get rolling, you guys know the drill. If you like this video, go ahead and click that like button down below. If you want to stay up to date on issues related to your Second Amendment rights, go ahead and click the subscribe button down below. Click the little bell logo if you want to be notified when we post new videos. And most importantly, let's keep the comments and discussions coming. That's how we're going to make sure we get our videos out to more lawful and responsible gun owners like yourself. Okay, so for those of you who are just getting up to speed, we did a video yesterday about Mr. Hero Delivery Guy, this guy right here, who out in Duvall felt that he needed to jump in on a verbal altercation, had nothing to do with it, pull a firearm out on a gentleman that we're calling Ron, and essentially endanger pretty much half of the city of Duvall. Now, I gave you guys yesterday 4 options. I said, hey, listen, no charges at all. He acted completely within lawful self-defense. He can be charged with unlawfully aiming or discharging a firearm under 941-230, which was a gross misdemeanor. He could be charged with unlawful display of a firearm under 941-270, which is also a gross misdemeanor. Or he could be charged with assault in the second degree under RCW 9A36.021. Now, although a majority of our viewers were clearly leaning towards that 4th option, I will admit, as the person who put the video together, I did put my thumb on the scale a little bit. There were a couple of comments for other suggestions that I thought were incredibly well thought out, and I want to spend a few minutes talking about that. The first comment comes from one of our viewers, Mike Mann, and Mike Mann stated, how about attempted kidnapping? He tried to hold the man against his will. Well, Mike Mann, you actually raise a good point. Now, in order to understand the plausibility of this particular theory, we need to understand 2 things. Number 1, what is kidnapping? And then number 2, what is attempted kidnapping? That is, what is criminal attempt? Well, criminal attempt is defined in RCW 9A.28.020 as follows. 1. A person is guilty of an attempt to commit a crime if, with intent to commit a specific crime, he or she does any act which is a substantial step towards the commission of that crime. 2. If the conduct in which a person engages otherwise constitutes an attempt to commit a crime, it is no defense to a prosecution of such attempt that the crime charged to have been attempted was, under the attendant circumstances, factually or legally impossible of commission. So criminal attempt is the step towards the commission of any particular crime, and the fact that the crime was impossible to commit is irrelevant to whether or not the person attempted the commission of the crime. So we're talking about attempted kidnapping. Now, kidnapping in Washington State is broken down into 2 degrees. Kidnapping in the 1st degree, kidnapping in the 2nd degree. Kidnapping in the 1st degree is found in RCW 9A.40.020, and it reads as follows. A person is guilty of kidnapping in the 1st degree if he or she intentionally abducts another person with intent, A, to hold him or her for ransom or reward or to use as a shield or hostage, 2, to facilitate a commission of any felony or flight thereafter, C, to inflict bodily injury on him or her, D, to inflict extreme mental distress on him, her, or a third person, or E, to interfere with the performance of any government function. And kidnapping in the 1st degree is deservedly a Class A felony. Now, I believe that perhaps under subsection D, we could have a person who is being abducted, intentionally abducted with the intent of inflicting extreme amount of emotional distress on him. But what exactly is abducted? I mean, did we see anything here that actually looks like an abduction? Well, that may actually be legally possible, because if we take a look at the legal definitions in RCW 9A.40.010, we learn that abduct is defined as, abduct means to restrain a person by either A, secreting or holding him or her in a place where he or she is not likely to be found, or B, using or threatening to use deadly force. And I think Mr. Hero Delivery Guy here clearly is threatening to use deadly force against our would-be victim, Ron. So does this really classify as kidnapping in the first degree? Probably not attempted kidnapping in the first degree. So what about kidnapping in the second degree? Well, RCW 9A.40.030 defines kidnapping in the second degree in much the same way that we define robbery in the second degree. In fact, this is a pretty well-worded statute because it reads as follows. A person is guilty of kidnapping in the second degree if he or she intentionally abducts another person under circumstances not amounting to kidnapping in the first degree. And so I do think, Mike Mann, that this is possibly an attempted kidnapping in the second degree, a Class B felony, but since it is an attempt, it automatically by statute reduces it down to a Class C felony. But it is an excellent point, and thank you for raising it. Now, our next comment comes from U.S. Defender, and this is an incredibly well thought out comment that I'm actually not going to have a huge response to because of how well he articulated it. But U.S. Defender states, I'm going with option 5, charging him with unlawful imprisonment per RCW 9.40.040, a Class C felony. Under that statute, a person is guilty of unlawful imprisonment if he or she knowingly restrains another person, and restrain means to restrict a person's movement without consent and without legal authority in a manner which interferes substantially with his or her liberty. When our delivery driver Hero told Ron to stay there while simultaneously pointing a gun at him, he restricted Ron's movements, thus substantially interfering with Ron's liberty without a legal authority to do so, and it was only when the driver's attention was momentarily distracted that Ron was able to escape. Assuming that Ron didn't exhibit some form of behavior that justified the driver's use of force, then the driver had no legal authority to hold Ron until the police arrived, and in doing so, he committed unlawful imprisonment, in my honest opinion. And this is absolutely one of the best comments that we've ever gotten here at Washington Gun Law. U.S. Defender, thank you very much. This is an incredibly well thought out and researched answer. And yes, in many ways, what he's talking about here is entirely legally possible. Because unlawful imprisonment is found in RCW 9A.40.040, and just like U.S. Defender states, the statute specifically states, a person is guilty of unlawful imprisonment if he or she knowingly restrains another person. And then just as U.S. Defender stated under RCW 9A.40.010, restrain is defined as, restrain means to restrict a person's movement without consent and without legal authority in a manner which interferes substantially with his or her liberty. Restraint is without consent if it is accomplished by physical force, intimidation, or deception, or B, by any means, including acquiescence of the victim, if the victim is a child less than 16 years old or an incompetent person. So, yeah, if I could go back and do that video all over, U.S. Defender, I think you've come up with an excellent statutory option here in which Mr. Hero Delivery Driver could be charged. Now, and in some ways, it may be a more appropriate charge. Assault in the second degree is a Class B felony, and we're not messing around with a Class B felony. That's serious. Unlawful imprisonment is still a Class C felony. It could forfeit his rights to possess a firearm, which may not be a bad idea for Mr. Hero Delivery Driver Guy. And so, U.S. Defender, this is an excellent question. Thank you very much for your contributions. Now, I hope what we're learning here as we work through this is exactly how much trouble we can get in by merely displaying a firearm when we have no lawful basis to do this. But a couple of other viewers brought up a couple of other points unrelated to what Mr. Hero Delivery Driver Guy could be charged with that also really, I think, helps illustrate the amazing problems that we can create if we act without lawful authority when pulling a firearm or pointing a firearm at a person. Randy Hootenanny actually asked the following. I am more interested to hear your opinion on what the legality would have been had Ron been armed with his own gun and taken a shot as soon as Mr. Hero turned his back. I carry every day, and my gut instinct would be that I am being held unlawfully by an armed aggressor, and as soon as my captor turned his back, I'd take the opportunity to end the threat against me. And Randy Hootenanny, that is an excellent point. So let's talk about that. What happens if Ron had been armed in that situation? Well, okay, let's get the baseline out. Under RCW 9A.16.020 subsection 3, we have the right to use any reasonable, necessary, and proportional force to defend any unlawful force that's being thrust upon us. We also know under RCW 9A.16.050 that we can use lethal force if we are in imminent threat of death or serious bodily injury. When we are having a firearm unlawfully pointed at us, as was the case here with Mr. Hero Delivery Driver Guy, yes, there is no doubt that Ron is in imminent threat of death or serious bodily injury. Could Ron take a shot in that situation? I believe he could. Whether he decided to wait until Mr. Hero Delivery Driver Guy was not looking or not, that's a tactical decision. That's not going to be the subject of this particular discussion. But is he facing an imminent threat of death or serious bodily injury? Yes, he is. And can he use lethal force to defend himself? Yes, he is. And I think that begins to demonstrate the problems. Because let's take this out to one of the logical conclusions. Ron pops off a shot. Now Mr. Hero Delivery Driver gets off a shot. And we got a shootout going across the street. And behind Ron is what? A park. And what's in the park? Well, we know there's at least a family of 4 in the park based upon what the police report said. So, Randy Hootenanny, this is an excellent question, not only because it does illustrate what Ron would have had the right to do, but it also demonstrates how this can go from bad to really bad really fast. Okay, and then the final question came from BB Wiggs, and I think this is an excellent question that we need to discuss as well. His question was, I agree with you as for the assault charge. One question. What if I rolled up on this situation, saw him waving the gun around, and drew my weapon to disarm him? Would I be in a good place legally? I observe a man pulling a weapon and flagging multiple people. I have no idea whether I might be next. I would, of course, call 911 to report. Your thoughts? Okay, BB Wiggs, this is a really good question. And as we saw in that video, there were other drivers that did start to pull up. So you come upon a scene, you don't know what's predated any of this stuff. You don't know about Ron getting hit by the lady in the minivan. You don't know about Ron getting into it with Mr. Hero Delivery Driver Guy. You just walk up, Mr. Hero Delivery Driver Guy is waving a gun around at all sorts of people, including Ron and the family of 4 in the park. Now, again, using our baseline of 9A16020 subsection 3 and 9A16050, all necessary, reasonable, and proportional force to defend yourself or other people in your presence. The use of deadly force is authorized if you are in an imminent threat of death or serious bodily injury, or others in your presence are in imminent threat of death or serious bodily injury. So, yes, could you pull up on Mr. Hero Delivery Driver Guy, draw your firearm on him in the hopes of disarming him? Yes, I suppose you could. What's the likely conclusion of that? Mr. Hero Delivery Driver Guy, who has no trigger discipline whatsoever, is going to turn on you, and away we go again. And now we're in the exact same situation where bullets are flying around a neighborhood with a park and a family of 4. And we begin to see how many things can go wrong and how fast it can escalate from bad to terrible to deadly in a matter of seconds by one poor choice. Listen, I thought these were great comments. They deserve to be highlighted, and I'm sure we'll be getting more. And we may do some more follow-up on Mr. Hero Delivery Driver Guy, because we do know that we're waiting word from the prosecution to see what will he be charged with. Listen, you may have more questions about this issue or anything related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, remember, part of being the lawful and responsible gun owner, not like Mr. Hero Delivery Driver Guy, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.